welcome to the PI show. My name's Harry Nowicki. I'm a solicitor and I'm with Tony Carbone, who's a lawyer who does personal injuries.
Good evening, Harry. Good evening, viewers.
And tonight we've got a special guest, Alan Thompson, who's an expert in Victoria, or dare I say Australia, about legal costs.
Thank you, Harry.
Good evening.
Welcome. Tonight we're discussing the vexed question of legal costs, which is a world of its own.
It is.
And before we go to that, Tony, you've got what's in the news.
Yeah, Harry, there's some interesting stories in the paper about doctors and, misconduct and doctors that have performed poor operations and people have died. Classic cases out of Jayant Patel.
He's been charged with criminal activities.
What's happened is that of late there's been a new body set up to govern the medical profession called the Australian Health Practitioner Regulation Agency. What the debate's about is whether doctors should be, the results of gross misconduct should be published for the public to see, and that way they say it would protect the public from these doctors.
But you'd think gross negligence, a lot of cases would be litigated, Tony. You'd think.
Well, see, what they're saying is there's been a lot of issues in relation to cosmetic surgeons and plastic surgeons and people like that. More so people that hold themselves out to be experts in cosmetic surgery, and they've got really, they don't have the qualifications or skills of a plastic surgeon. And they say that there's a lot of serial offenders, botched operations, and the public don't really know much about them because all the public are trying to do is save cost, and they're going to the cheapest person. But is the cheapest person the appropriate person to be conducting the operations?
Well, look, at the moment they're not published, I don't think. So there's proposal.
Well, it's not mandatory,
no,
Harry.
it's proposal, and we'll see. But I mean, my view is that I don't think it'll make much difference either way.
Well, the biggest concern for the doctors is one, the privacy situation.
Intrusion of privacy.
And secondly, they're worried that there's going to be an explosion in claims against doctors. And more to the point, they say that it's going to cost the system so much more money, and it's already drained of resources as it is. The health system's really suffering in terms of finances.
And this is plus insurance as well.
That's exactly right.
Yeah.
And also it puts them in a state of panic, and who knows, they might start making mistakes because they get a bit too worried, and who knows.
But look, we've discussed medical negligence in the past, and I think, look, we ran a case of cosmetic surgery.
Yeah,
as
we
well,
did.
That you're involved in that succeeded, Tony.
Yeah, it was an interesting case because in that one there, the doctor involved wasn't even insured. There was a mistake somewhere along the lines. Her insurance had expired, and she said she took out insurance with another company, but
we're not quite sure. Yeah,
very complicated.
Yeah.
And I mean, she's put herself at risk now because the governing body's basically looking at her to see what the story's all about. So, yeah.
But look, tonight we just this show's been prompted by a question from a viewer about what was a call-to-bank letter or an offer of compromise, and
very interesting.
We thought we might devote a whole show to this question because Alan, it raises the issue about legal costs.
It does.
And legal costs, I think the bottom line for most people is if they win a court case, they think that the other side should pay. Costs follow the event in most cases.
In most cases.
And they think that the other party should pay all their legal costs.
They do.
But that's not the fact, is it?
It's not the fact.
There's a misconception out there, isn't it?
There is. Particularly with most clients who undertake litigation, they believe that if they win, they're entitled to all their costs, but that's not the case. The costs are really governed by Order 63, capital A of the Supreme Court rules, which provide that 6330 provides party-party costs. Now, party-party costs means that if you're successful in a proceeding, that costs follow the event and therefore costs should be paid by the losing party. Unfortunately, on a party-party basis, costs somewhere falls between 50 to 60% of those costs incurred by the client.
So the client's got to pay an extra 30 to 40% of those costs.
Well, it also depends on the type of litigation. If it's accident compensation in Victoria, there's a real problem there, isn't there?
There is a problem. Under the legislation, the client loses 20% pursuant to the ministerial directions, and therefore under that Act, under Section 134, capital A, B 29, 20% falls of the successful party's costs.
And that includes barristers' fees, which is a real big issue.
Indeed. A recent decision where where the judge had ordered costs certified, that is that the costs were fixed and therefore couldn't be interfered with. We have a situation where a decision of jury meant that 20% of loss of certified fees. For example, if a judge had certified 5.5 for a senior counsel, it's now been reduced by 20% and that's $4,400. So the poor client has to make up the difference of the $1,100 plus conferences and any other costs certified by counsel or for counsel, and unfortunately the client wears the cost of that.
But you know, legal costs have a whole, I think, quite interesting history. But the fact is that there's ways and means in which you can put pressure on the other side in terms of legal costs. Indeed. In the course of litigation.
Indeed, there is.
What are they?
And those are, unfortunately, pursuant to the legislation, work cover cases cannot be protected by way of offer of compromise or cultivate letters, as the legislation denies that.
Yeah,
it's a big problem, I think.
It is a big problem because it doesn't allow flexibility by the parties in running the case and changing fact situations as they evolve.
Correct. And
so it's a very, to my mind, a very rigid system and a very unfair system for both, in effect.
What's poor with the system, Harry, is that when the offers are put by the defendant and then a counter offer is put by the plaintiff, it's so early in the proceeding that not all information's in, as you'd put it.
Yeah, but the information can change in the course of proceeding.
Change.
Witnesses,
discovery, interrogation.
And in effect, you're stuck with, as I agree with you, Tony,
very early
on in the proceeding, even before proceedings are issued.
That's exactly right.
You've got to formulate offers and counter offers, and then you can't depart from that.
That's correct.
And plus, you might go in a bit too high if you're a plaintiff, Harry. You know, information comes out down the track and you've got issues.
That's not helpful.
No, that's right.
But it's a rigid system.
It is.
It's a system which I think doesn't allow for any flexibility, creativity by lawyers.
The system hurts the injured party more than anyone else.
It does.
Yes.
It locks defendants and plaintiffs into a system where legal costs can be significant. But and the issue of legal costs can be significant. But look, we're coming back after the break. We've got to go to
sponsors break, so viewers, don't go away. Keep watching. It's very interesting, and we'll come back with the case of Calderbank. Thank you.